Good evening, everyone. I hope the screen is visible. Okay. So in the previous class, we had completed till acceptance. That what does it take to accept an offer? So today we'll be starting with consideration. Now, what is consideration? Consideration in simple terms can be understood as the price that you are paying for executing the contract or for entering into the contract. A simple example for the same could be, suppose you'd gone to buy a packet of milk. You give 20 rupees or you give 50 rupees, whatever, to buy a packet of milk. Then in that situation, that 50 rupees is the consideration for the shopkeeper to enter into the contract. And that packet of milk is the consideration for you. Consideration is one of the most essential features under the Indian Contract Act. And the Indian Contract Act clearly says that a contract entered into without consideration is actually no contract. Now, when I say that a contract entered into without consideration is no contract, that means that it still remains an agreement, but it is an agreement which is not enforceable by law, right? And as we all know that a contract is nothing but just an agreement which can be enforced by law. So an agreement enforceable in the eyes of law becomes a contract. Consideration is amongst those basic essentials such as offer, acceptance, capacity of the parties, without which a contract can never be formulated. And a contract without consideration is no contract, or so to say, is a void contract. Now, how the Indian Contract Act defines consideration? When at the desire of the promisor, the promisee or any other person has done or abstained from doing or does or abstains from doing such act or abstinence is called as consideration for the promise. Now, before getting into the details of the definition, let's first discuss what exactly is a promise. An offer, when accepted, becomes a promise. So offer plus acceptance is equal to a promise. What promise does? It brings a finality. That means once a promise has been achieved, now the parties cannot retract back from it. मतलब वो उस प्रॉमिस से को ये नहीं कह सकते कि मैं इस वादे को तोड़ता हूं. नो. The definition says when at the desire of the promiser, that means the one who is making the promise, the promisee, or any other person. So consideration can also move from any person who is not even a party to the contract. Now, By saying so, I'm not saying that all those people who are not party to the contract वो भी consideration दे सकते. No, what I'm trying to say is that suppose I have to give 50 rupees to Mr. A and Mr. B also owns me 50 rupees. So what I can do is I can ask Mr. B to pay Mr. A 50 rupees, which Mr. B owns to me, right? Now here the contract is between Mr. A and me, but the consideration can move with respect to a third person as well. Sometimes there can be a situation where the contract is for the benefit of a third person. Example being a minor. So the definition further goes on to say the promisee or any other person has done or abstained. तो उसने कुछ चीज करी है उस promise के basis पर या कोई चीज नहीं करी है, whatever way it was asked in the promise or whatever the promise demanded. So such act or abstinence is called as consideration for the promise. Now, suppose आप गाड़ी खरीदने गए, आपको गाड़ी पसंद आ गई, 10 लाख रुपए की कार है, आपने एक डाउन पेमेंट कर दिया 50,000 रुपए मान के चलिए. The contract has been formalized because some consideration has been paid, part consideration has been paid. Am I clear with this?
Yes, sir.
What is also interesting to see is the framing of the definition under the Indian Contract Act. It says has done or abstained or does or abstains. Then such act or absence is called as consideration. So it clearly means that the consideration can be past, present as well as future. Past consideration क्या हो सकती है? मैं आपके लिए एक बार 50 रुपए का कुछ सामान खरीद के लेकर आया. So you owe me 50 rupees now. Now आप मेरे लिए कुछ सामान खरीद के लेकर आए एक दिन जाके, उसका भी प्राइस 50 रुपीज ही था. Now I say कि जो 50 रुपीज आए, जो 50 रुपए आपको मुझे देने थे, now that becomes adjusted with this 50 rupees. Now here the consideration was past. Am I clear with the past consideration? Could you re-explain, Prarthi, which part? Past. Okay, so past consideration is something where the consideration was already given in the past, right? So the example that I gave, because suppose I bought something for you and the price of which was 50 rupees. Now, in such a situation, what you did, you didn't pay me back 50 rupees. Now, one day you bought me something of 50 rupees. I said that adjusted with the 50 rupees of past. Now here that 50 rupees is a past consideration. It can be present. Simple. I gave 50 rupees to buy a packet of milk. He gave me a packet of milk. Simple. This would be a case of present consideration. The third one is future consideration now. future consideration is very interesting. It can occur in two forms. Either the consideration would be decided today, but the payments would be made later on. That means only the execution would be futuristic. Now, why? Why the consideration? Present consideration. अरे प्रेजेंट कंसिडरेशन तो सबसे सिंपल है कोमल. जो तुम पेन खरीदती हो, मान के चलो तुमने पेन खरीदा मार्केट से जाके, तुम क्या कर रही हो? उसको 10 रुपए दे रही हो, पेन ले रही हो. ठीक है, जो हम रोजमर्रा में जो हम करते हैं, दैट इज बेसिकली योर प्रेजेंट कंसिडरेशन. Then comes future consideration. So future consideration, as I was saying, it can occur in two forms. One is where you decide the consideration today, but the payment is futuristic. That payment would be made at a later stage. So in that situation, only the execution is futuristic, right? Another situation could be of future consideration is where it is dependent upon something. I'll give you a simple example. स्टॉक्स के बारे में आपने सबने सुना ही होगा. आपने मान के चलिए शेयर्स खरीदे हैं, तो शेयर्स की प्राइस आज के टाइम में मान के चलिए 10 रुपए पर शेयर है किसी का पर्टिकुलर कंपनी की. नाउ व्हेन यू बाइंग शेयर, देयर इज डेफिनेटली अ कॉन्ट्रैक्ट. बट जब आप उन शेयर्स को बेचेंगे, तब कंसिडरेशन कौन सी होगी? जो उस टाइम पर होगी, which in a sense is dependent upon future time. It may go down, it may go up. Money given in advance is which type of consideration? Down payment, if it is, which is down payment only, Prarthi? Yes, it would be present. The contract has come into existence at that very point of time. तो फ्यूचर कंसिडरेशन जो है उसमें एग्जीक्यूशन फ्यूचर में होगा. इट मे बी डिसाइडेड टुडे, or there can also be a situation where the price of the contract itself would be decided in future depending upon the facts and circumstances, right? So stock market could be one example of it. Another example could be your future trading. ठीक है, अगेन स्टॉक का एक एग्जांपल है ये भी फ्यूचर का. So that is how consideration can exist in three situations. But do remember that without consideration, there would be no contract. Now, another important part that comes into play is that what should be the value of consideration? Can anything be a consideration, or does it should have some tangible value? Yes, class, what do you think? क्या कंसिडरेशन की कुछ अपने आप में कुछ वैल्यू होनी चाहिए, या कंसिडरेशन कुछ भी हो सकता है? क्या क्या ये कंसिडरेशन हो सकता है कि मुझे बहुत खुशी मिलेगी? Right. So Anvesha says no. Prathis again says should have some value. Devesh says no. Komal also says no. What about others? Right. So it's simple. The consideration should have some value in the eyes of law. It's as simple as that. It may be 1 rupee, it may be 10 rupee, it may be 100 rupees, or it may be convertible into a valuable security. But it should have some value. Until and unless it does, excuse me, until and unless it does not have any value in the eyes of law, it will not be called as a consideration. So that's what the next topic is. What are the essentials of a valid consideration? Now, now the first essential is that consideration must move at the desire of the promiser, which is exactly the first line of the definition. Right? At the desire of the promiser. So one who is making the promise, right, to pay, for example. So suppose you want to buy my house and I gave an offer of 50 lakh rupees and you said, fine, I'm willing to pay 50 lakh rupees for it. So the consideration is moving from whom? From whose end? From my end. Because I am the promiser that I am promising to buy it for 50 lakh rupees. Am I clear with the first point? The second part, the second essential rather, is it may be furnished by any person, not necessarily a party to the contract, which we discussed in the previous slide as well. That consideration can be furnished by any person who may not be a party to the contract. And still it would be a valid consideration. Suppose, let me just give you an example. Suppose there is Mr. A and he has a son, Mr. B. Now he says that I will transfer all my wealth to you, provided you will take care of my daughter, which is C. And every month you want to pay her a certain amount of money. Now, here the contract is being entered between me and Mr. A. Sorry, Mr. A and Mr. B. And who is the beneficiary? Mr. C or Miss C rather. Now, if Mr. B refuses to pay the monthly maintenance amount or the monthly amount to Miss C, can Miss C claim the money from Mr. B? Okay, reason being, please come up with reason as well. This is a legal reasoning class. I'm not going to do that, Prarthi. Let me complete this, then I'll go back. But was C a party to the promise? Was a party to the contract? Now here C was not a party to the contract, but still C can enforce it because there is a consideration and there is a condition in the contract that Mr. B has to pay some money to Mr. C or to Miss C. Then in that situation, Miss C can implement the contract despite not being a party to it. Now, yes, Prarthi, what is your confusion? Yeah, so what you didn't understand about the second point? Okay. Second point. Okay. Second point in simple terms says that consideration can move at the desire of the promiser by the promisor or any other person. Do you remember that example? जहां पर मैं पैसे ओन करता हूं मिस्टर बी को और मिस्टर सी जो है कुछ पैसे मुझे ओन करते हैं और फिर मैंने क्या किया मैंने बोला कि मिस्टर सी को कि आप जाके मिस्टर बी को पैसे दे दो जो आप मुझे देने वाले थे यस दिस इज एग्जैक्टली व्हाट सेकंड सिचुएशन इज need not always benefit the promiser again true the example that we just discussed of Mr. A, Mr. B and Miss C there is nothing for Mr. A to benefit from it yes or no मिस्टर ए वो है जो पैसे अपनी सारी वेल्थ दे के जा रहा है मिस्टर बी को then comes the fourth situation which is consideration must be of some value in the eyes of law now consideration should have some value in the eyes of law that means it should have some tangible value. Tangible value means it can be in the form of money or is capable of being converted into money. Right? So suppose somebody says तुम मुझे खून दो मैं तुम्हें आजादी दूंगा and people accept this offer. Is it a valid consideration in the eyes of law? No, right? The reason being simple. Azadi may be of utmost importance, perhaps, but it does not have any value, any intrinsic value in the eyes of law. And due to this very reason, promises which have no consideration or have no consideration in the eyes of law would be no contract. Suppose if I say if you do this work for me, right? if you do this work for me, this X work, I will be a slave of you for the rest of my life. Is it a valid consideration? And we are not getting into a debate that whether slavery is legal or not legal, because then that would be completely defeat the whole purpose. Again, the answer would be a no, because it does not have any value in the eyes of law, which is slavery. Right. Then comes the next important essential, which is consideration need not to be adequate. Now, suppose I have a house which is worth 50 lakh rupees, but I'm facing some difficult financial times, as a result of which I am willing to sell my house. Now, Mr. B knows this thing, and he says to me that I will buy your house, but for 25 lakh rupees. I say, okay, fine. I sell it. Can later on I say that the contract is not valid because the consideration was not adequate? Yes, class. Is the question clear? I hope the question is clear to everyone. Okay. So, Upasana, you have said, you asked me adequate means what? Okay. Adequate means, Upasana, that it should not exactly be of that same value. It may be less, it may be more. What matters is it should have some value in the eyes of God. So, can there be a contract for 1 rupees where the consideration is 1 rupee? Yes. I'll give you 2 examples of it. Generally, जो हॉस्पिटल्स होते हैं, स्पेशली प्राइवेट हॉस्पिटल जो कि चैरिटेबल इंस्टीट्यूशंस होते हैं कुछ, तो जो चैरिटेबल इंस्टीट्यूशंस होते हैं या एजुकेशन इंस्टीट्यूशंस होते हैं चैरिटेबल, उनको जो जमीन दी जाती है दैट इज जनरली गिवन एट अ वेरी लो प्राइस. It is 1 rupee, 2 rupee, 5 rupees per, per square yard or something. Another real life example of this is the movie Bhag Milkha Bhag, where Milkha Singh, to enter into a contract, took only 1 rupee as consideration. The great Milkha Singh. And in contrast to this was MS Dhoni, the movie, where MS Dhoni charged a hefty amount to enter into the contract for selling his story. So you can sell 5 rupee की चीज को 50 रुपए में, very valid. You can also sell 50 रुपए की चीज को 5 रुपए में. Right? It is very much allowed in the law. What it only says is that it should have some value. It need not to be adequate. That means it should not be equal to what the actual price of the object is, but कुछ ना कुछ वैल्यू होनी चाहिए, चाहे वो 1 रुपए हो, 10 रुपए हो, 5 रुपए. So you can even sell a palace for, peanuts. And the law will not held it to be wrong, or the law will not hold it to be wrong. Am I clear till here? Yes, Upasna, is it clear to you, your query? Have I addressed it? Now, the last one is consideration must be real and competent. Real means it must be real in this physical world, which is can you say कि मैं तुम्हारे लिए चांद तारे तोड़ के ले आऊंगा? Again, the answer is a we can say, but it is nonsense. Well, I was saying it in the sense of law, that can you say it, not in the sense of nonsense. Similarly, can you say that I will take you for a trip to Mars? If you do this work for me, I'll take you to Mars for a trip. Is it a real consideration? Right. It is not real. So something which is physically impossible, something which is legally impossible, something which is uncertain, and something which is illusory, or either of the four. So something which is just not possible would qualify under the category of unreal consideration. No, it can't be a future consideration. Why? Because future consideration can't be something which is not present in the present self. Am I clear, Kushal? Right? So these are the essentials of a valid consideration. Now, there are certain situations or cases where the Contract Act makes exception. Exception in the sense the Contract Act allows certain contracts to be without consideration as well. Now, what are these? So let's discuss them one by one. There are only three kinds of cases that the Contract Act recognizes. Where the contract can be entered into even without consideration. As a general rule, we all know that there cannot be any contract without consideration. Now, the first exception. The first exception is when an agreement is made out of love and affection. ठीक है? Agreement किससे derive होना चाहिए? Love से and affection से. It must be made between parties in near relationship. So there must be a near relationship between the parties. It must be made out of love and affection. It must be made in writing and then it must be registered. Remember this. A contract or an agreement made out of love and affection, provided the parties are in a near relationship with each other, the parties have entered into that agreement out of love and affection. Such agreement must be in writing and then it must be registered. So can a father sell his car to his son for no money? Yes. Can the same be also can the same be considered to be true with respect to husband and wife as well? No, Komal, why? Are you saying that husband and wife don't love each other? Yes, Komal. Why no? They are equal partner to their property. So if a car is owned by the husband, you are saying that that equally belongs to the wife as well? No, that is not the case. Legally, जिसकी गाड़ी जिसके नाम है उसी की होगी. Right? After husband death, एक second, Komal, what are you thinking? एक agreement हुआ वो अग्रीमेंट जो है विदाउट कंसिडरेशन है, और वो क्यों किया गया? बिकॉज आउट ऑफ लव एंड अफेक्शन। तो मान के चलिए हस्बैंड है, हस्बैंड ने अपनी गाड़ी जो है वो अपनी वाइफ के नाम कर दी, क्या उसके लिए कुछ पैसे की जरूरत है देने के लिए वाइफ को? एग्जैक्टली, नो। यही है अग्रीमेंट मेड आउट ऑफ लव एंड अफेक्शन। So apart from the agreement being made out of love and affection, the parties must be in a real near relationship. It must be in writing and it must be registered. Now, can the same situation of husband and wife be also be applied to girlfriend and boyfriend? I repeat my question. Can the same situation of husband and wife also be applied to a girlfriend and a boyfriend? Please come up with reason. Kushagra says no. Reason being, Kushagra?
Because sir,
And
they are not yet in a close relationship.
they are yet not in a near relationship. Okay. Devesh, what about you? Right. Right. So I'll answer this. What about the situation would be of a fiance? Can the same situation of husband and wife be applied to people who are engaged? Prarthi, we are assuming that it is being done out of affection and love. Kushagra says no. Okay. Third situation also I'll take. What about people who are in a live-in relationship? Very right, Kushagra. The answer to all the three situations is a no. Why? Because there exists no legal relationship between the couple in the eyes of law. The law is very interesting in the sense that it only recognizes one union between a male and a female, that is of marriage, and anything before it cannot be considered as a near relationship. फ्रेंडशिप को रिकॉग्नाइज फिर भी कर लिया जाता है, बट वी हैव टू लाइक प्रूव इट लाइक बियॉन्ड reasonable doubt, like too much, almost next to impossible. Also, the word says near relationship, so there must be in some sort of relationship, and that relationship should be of some value, or rather, the relationship should be such which is recognized by the law. Girlfriend, boyfriend, they may exist for all practical purposes, but not for legal purposes. Fiance, again, engagement, but is a relationship in the middle of somewhere. तो जब आपकी शादी हो जाएगी, then suddenly the situation would change, but not before that. And the same would apply to a live-in relationship. Am I clear? Any doubt? Any question? या ब्लड रिलेशनशिप तो हस्बैंड एंड मतलब सॉरी हस्बैंड एंड वाइफ कह रहा हूँ, ब्रदर सिस्टर हो गया ना. एक्चुअल में लॉ जो है वो दो ही टाइप के रिलेशंस को रिकॉग्नाइज करता है, बाय ब्लड और बाय लाइक प्रोजेनी और बाय मैरिज. Right now, in a case of a girlfriend boyfriend, there is nothing, and same applies to fiance and other things as well. I hope that clarifies. Yeah, is it clear to everyone? Now, let's move ahead to the second one, which is agreement to compensate for past voluntary service. मान के चलिए आपके बीच में कोई एग्रीमेंट हुआ जिसमें आपने ये कहा कि जो तुमने मेरे लिए उस टाइम पर फ्री में सर्विस दी थी, मैं उसका तुम्हें मतलब कॉम्पनसेशन दूंगा, मुआवजा दूंगा, या उसका कुछ वो करूंगा. फॉर एग्जाम्पल, suppose somebody was in need of some money for the purpose of marriage of their son or daughter, right? Am I audible? Okay. Now, और मैंने क्या किया, मैंने जाके कुछ 50,000 रुपए दे दिए कि भाई तेरे को भी पैसे की जरूरत है, तू रख इसको. उस बंदे ने कहा कि जैसे ही मेरे पास पैसे आएंगे, मैं आपको ये 1 महीने के अंदर अंदर रिटर्न कर दूंगा. मेरे पास 1 महीने के अंदर पैसे आ जाएंगे, आप मुझे 2 महीने का टाइम दे दीजिए, मैं आपको 2 महीने के अंदर मेरे पैसे रिटर्न. व्हाट इज दिस? दिस इज एन अग्रीमेंट टू कॉम्पनसेट फॉर द पास्ट वॉलंटरी सर्विस. इट इज नॉट अ उधार, राइट? नीड टू अंडरस्टैंड इट. इट इज नॉट अ डेट. इट इज जस्ट ही हैज गिवन हिम दिस मनी कि भाई तू इससे अपनी बेटी या बेटे की शादी कर दे. And out of morality, that person has said, I will pay back this amount to you, but give me some time. Now, this is an agreement to compensate for past voluntary service. You cannot say later on कि भैया consideration तो था ही नहीं, तो फिर contract कैसे बना? No. So if there is something that you have done in the past and the other party now wishes to pay for it, it can very well be allowed. Am I clear with the second point? Third point. Agreement to pay a time barred debt. Now, what is a time barred debt? Time barred debt is basically a debt which cannot be enforced anymore in a court of law. So what happens is, okay, take any example of past voluntary service. कोई भी voluntary service का example ले लो. जो भी तुम्हें ठीक लगे. कुशाग्र? अरे पास वॉलंटियर सर्विस कुछ भी हो सकती है, मान के चलो मैं तुम्हारे लिए मिठाई लेकर आया, ठीक है, और मिठाई जो थी वो मैंने तुमको दी, उसके बाद क्या हुआ, तुम एक बार बाजार गए और तुम, सॉरी, मैंने तुम्हें मिठाई दी और तुमने कहा कि सर इस मिठाई का कर्जा मैं उतारूंगा या जो भी, ठीक है, जैसे भी तुम एक दिन बाजार गए, तुमने मुझे मिठाई दे दी, या फिर आपने पास्ट में कोई वॉलेंट्री सर्विस करी थी, फॉर एग्जाम्पल ब्लड डोनेशन किया, और जब हमने ब्लड डोनेशन किया तो मैंने कहा कि आई विल कॉम्पनसेट यू फॉर दिस बाय 10,000 रुपीज, 11,000 रुपये दूंगा मैं तुमको। खून देने के बाद कैन यू क्लेम 11,000 रुपीज? Yes, you can. This is exactly what second point is saying. Agreement to pay for the past voluntary service or to compensate for the past voluntary service. What is the past voluntary service? Donation of blood. Now I promise that I will give you 11,000 rupees. If I don't pay, then you can claim. Now you understood. Is it clear? पक्का? Don't take your doubts home. घर लेके मत जाना अपने डाउट्स को। ठीक है, वॉलेंट्री सर्विस वो होती है जो कि फ्री ऑफ कॉस्ट होती है, राइट? सो अगर वो किसी ने किया और उससे आप खुश हो गए तो, और आपने ये कह दिया कि भैया मैं तुम्हारे लिए ये करूंगा, तो फिर वो कॉन्ट्रैक्ट बन जाए। सो नाउ कम्स द थर्ड पॉइंट, कॉन्ट्रैक्ट विदाउट कंसिडरेशन. My third point is, which is the third example, the third situation where there can exist a contract without consideration. Agreement to pay a time barred debt. What is a time barred debt? Time barred debt is basically a debt which cannot be enforced in a court of law. Now, under civil law, there is a law called as Limitation Act. Limitation Act ये बताता है किसी भी चीज के लिए आप कब तक, कितने टाइम पीरियड के अंदर अंदर केस फाइल कर सकते हैं। अगर आपने उस टाइम पीरियड के अंदर केस फाइल नहीं किया तो फिर your claim would become time barred, that means prohibited by time, and as a result of which you cannot seek remedy under the court of law. No, the word here is agreement. See the word Upasna, sorry, what's your name? Upasna, yeah. The word here is agreement. So when parties have agreed to compensate for the past voluntary service that was rendered, right? The voluntary service was rendered in the past, remember? Now is it clear? There's a difference between agreement and contract. Yes, is it clear, Upasna? So when when parties agree to pay for the time barred debt and they do it in writing and it is signed by the debtor, then also it becomes a contract without consideration and it can be enforced. Simple example, suppose I gave Mr. X 10 lakh rupees and he said that I will return this to you in 2 years. He did not return. So now the money becomes due on the first day after 2 years, right? Now what happens is, तो मान के चलिए फॉर एग्जाम्पल लेके चलते हैं कि आपने अगर किसी को पैसे उधार दे रखे तो उसको क्लेम करने के लिए आपके पास टाइम लिमिट है 3 साल। तो आपका 3 साल अब कहां से कैलकुलेट किया जाएगा? जिस दिन से डेट ड्यू हुई, मतलब 2 साल के लिए आपने दी तो 2 साल 1 दिन से आपका टाइम पीरियड कैलकुलेट होना स्टार्ट होगा और वो 3 साल तक, सो द नेक्स्ट 3 इयर्स। वो 3 साल भी निकल गए, आपने केस नहीं किया। उसके बाद क्या हुआ, आप दोनों के बीच में अग्रीमेंट होता है कि ठीक है मैं पे करूंगा तुम्हारा पैसा, और वो साइन हो गया, रिटर्न में आ गया। तो इस सिचुएशन में भी वो कॉन्ट्रैक्ट में कन्वर्ट हो जाएगा इवन दो देयर इज नो कंसीडरेशन, बट स्टिल इट वुड बी कंसीडर्ड एज अ वैलिड कॉन्ट्रैक्ट। Yes, is it clear the third situation?
So,
Yeah.
there is a consideration of 10 lakhs rupees which X has to pay. So, how can it can't be it is a without
Why it cannot be okay? Why it cannot be considered as a consideration, right?
Yes.
Yeah. So it cannot be considered as a consideration because the time limit to claim that amount has already lapsed, right?
Okay.
So it becomes a time barred debt. A time barred debt basically is a situation which means that you cannot enforce your debt in a court of law. And something which cannot be enforced in a court of law cannot be a valid consideration. Now you understood?
Yes, sir.
Huh?
Yes, sir. Understood.
Understood, right? So the effect is that of contract without consideration, right?
Okay, sir.
Yes. Are the three situations clear? Yes, class. Is this slide clear to everyone? Fine. So now we'll move to the next topic, which is free consent. Now, what is free consent and why free consent is important? Yes, class. Why do you think that consent is important for a contract? Anyone willing to answer?
Sir, if consent is given, then the promisor cannot claim that without which someone has made the contract.
Try to simplify it more. That
It
why
clarifies the
consent is
will of
important for
the
a contract?
persons who have made the contract.
Sorry, I could not hear you because your voice was lagging. Can you repeat?
It clarifies that both the people who had made a contract are willing to make that contract.
Are willing to make that contract. Okay. And why willingness is of so much importance?
Without willingness, the contract can be challenged in a court of law.
Right. Okay. But why willingness is so important? I understand that it can be challenged, but why is it so important? That it must be shown that parties were willing to enter into the contract.
If the willingness was not there, then it will be recorded as a forced contract and hence will be invalid.
Yeah, that is the effect, which you're right. But why there is so much emphasis on it?
So that I don't know. Please elaborate.
Yes, anyone else?
Sir, to prevent a wrongful loss or wrongful gain to any person.
Yeah, fine to an extent, but again, that is again a very secondary reason. What's the first reason? What's the primary reason? Remember the first class. Because consent shows intention of the parties. Clear? And intention to enter into a contract is the primary factor which would provide a validity to an agreement. Remember the case of Balfour versus Balfour. Mr. Balfour versus Mrs. Balfour. Yes or no? So,
So we were
क्योंकि
not there in that class. So can you explain that case?
the case, what's your name? I forgot.
Kushagra.
Kushagra. The case is basically about that a contract can only be enforced against parties if they have shown intention that they want to enter into a legally binding relation. Right? So the situation was that there was Mr. Balfour and Mrs. Balfour. Mr. Balfour जो थे वो British Army में थे, and suddenly he was posted to Sri Lanka. This was pre-independence, so Sri Lanka was a colony. Now he said to his wife that I will give you a certain amount of money every month. Now he started sending it, and he sent it for some time, but उसके बाद उसने discontinue कर दिया. So Mrs. Balfour sued her husband, saying that he has entered into a contract with me where he has categorically stated that he will give me certain amount of money. So now he should be held liable for breach of contract. The court held that there was no intention between the parties to create a legally binding relationship. Right? They wanted to, Mr. Balfour wanted to give money to his wife because it was more of a moral obligation. Right? They did not do it because ऐसा नहीं था कि एक legally binding relationship वो create करना चाहते. ठीक है कि अगर वो follow नहीं करेंगे then there would be consequences. Right? So this is what the case is about. Now you understood that why consent is important, that how consent helps to justify the intent of the parties.
Yes, sir.
So for a valid contract, there has to be free consent. The consent must be given by parties who are capable of giving consent. So who all are capable of giving consent? Who are capable of giving consent in the eyes of law?
The people in between the contract has made.
People,
The people who have made the contract.
Yeah, but who all are those people who can enter into a contract? Can a person of unsound mind give consent? Kushagra?
Sir, please re-ask the question.
Can a person of unsound mind give consent?
No.
No, exactly. So that becomes one category. That means they are not capable of giving consent. Similarly, minors, persons below 18 years of age, probably uh, you guys are also not capable of giving consent in the eyes of law. So 18 साल से कम उम्र के बच्चे, insane, these people are not capable of giving consent. So, right? Then consensus must be in the same sense and must be of the same thing, which is called as consensus addendum, which is agreeing upon the same thing in the same sense. Now, let me make you understand this with the help of an example. Suppose I have a car named Ferrari and I have a horse named Ferrari. I wanted to sell my horse named Ferrari to Mr. Y. Mr. Y thought that I want to sell my car Ferrari. The price was also agreed upon. Mr. Y came to take the delivery and I gave him my horse. He said, but I to have come for purchasing your Ferrari car. Now, is there a consensus upon the parties, between the parties? Have they agreed upon the same thing in the same sense? No, right? So, when parties to a contract are talking about completely two different objects or two completely different things, then there cannot be any consensus. And without consensus, there cannot be any meeting of mind. Right? And till the time there is no meeting of mind, till then there can never be a agreement. Until there is never an agreement, it can never be a contract. I'll just repeat what I said. Agreeing upon the same thing in the same sense, consensus addendum. Parties जो हैं, they should agree about the same thing. घोड़े के बारे में बात चल रही है तो घोड़े की होनी चाहिए, गाड़ी के बारे में बात हो रही है तो गाड़ी की होनी चाहिए. सेम सेंस में अग्री करने चाहिए अबाउट द सेम थिंग. नाउ अगर वो अग्री नहीं करते हैं तो देयर इज नो कॉन्ट्रैक्ट. व्हाई? बिकॉज if they have not agreed upon the same thing in the same sense, that means there is no meeting of mind. That means both the parties have not unanimously decided upon the same thing. So जब meeting of mind नहीं होगा तो agreement नहीं हो सकता. क्यों नहीं हो सकता? क्योंकि agreement के लिए क्या जरूरी है? Both parties should agree upon the same thing in the same sense. So once there is no meeting of mind, there is no agreement. And once there is no agreement, there can never be a contract, because ultimately contract is what? Contract is nothing but an agreement enforceable by law. Am I clear with this, that why free consent is important? So what would be the effect? So the effect would be the contract would be, or the agreement would be void in some cases and it would be voidable in other cases. So free consent कैसे vitiate होता है? तो फ्री कंसेंट को कवर करने के लिए 5 सिचुएशंस के बारे में बात की जाती है। कोवर्जन, अनड्यू इन्फ्लुएंस, फ्रॉड, मिसरिप्रेजेंटेशन एंड मिस्टेक। इसमें अगर मिस्टेक है दोनों पार्टीज का तो कॉन्ट्रैक्ट वाइड होगा, और बाकी चारों केसेस में, दैट इज कोवर्जन, अनड्यू इन्फ्लुएंस, कोवर्जन, अनड्यू इन्फ्लुएंस, फ्रॉड एंड मिसरिप्रेजेंटेशन, इन चारों में क्या होगा, सिर्फ और सिर्फ voidable होगा. The difference between void and voidable is clear to everyone. That what is void and what is voidable.
So could you elaborate more? I didn't quite get the difference.
Void and voidable. कौन था प्रार्थी? Was it you?
Yes, sir.
Prathi, you were there in the class when I discussed void and voidable.
Yes, sir.
हाँ. So how come you don't remember?
So could you just elaborate a bit more? I guess I'll remember it.
Elaborate a bit. Fine, I'll explain it later on. I'll ask the other fellows. Yes, anyone who is willing to explain the difference between void and voidable. Yes, Upasana, go ahead. Fine, Devesh, that's not an issue. I'll explain. Yes, Upasana. What's void and what's voidable? Some pages of memory. You have the slides, right? Yeah, Kushagar, go ahead.
Sir, void means that contract has no value, and
No
voidable
value in
means
what sense?
actually the contract is not made in that sense. May by mistake that contract is made between the persons, but according to the law, there is no contract between those persons because of the error in meeting of mind.
Okay.
Whereas in the
So
voidable case,
that basically is null.
yes, sir, zero,
Right.
null, whatever you say.
Yeah.
And voidable means that it is not acceptable. It is a fraud, like that. According to law, it is
Is
illegal.
okay. नहीं, वो illegal अलग होता है contract.
Okay, means it's not acceptable. It's wrong.
हाँ, void तो ठीक है, voidable अभी मैं बताता हूँ कैसे. Yes, Upasana, you said that you also know. अरे try तो करो at least.
So,
Yeah.
so is it something like the cases that are void, they're like completely void, and the ones that are voidable, they are contracts, but they are not enforceable by law?
No. Void contracts are not enforceable by law.
So like the contract that are void when you start them, and maybe the contracts that are legal, a valid contract when you start it and then they become void. So can they be void?
Wait, Prarthi, wait. You are utterly confused. Wait. Yes, anyone? Actually, this is your first class of legal. Okay, no issues. Are to at least say, guys, in my class, it's going to be very participative. ठीक है, तो बिल्कुल ऐसे कोई मैथ्स या साइंस की क्लास नहीं है कि मैं एक आऊंगा और बस आके डिक्टेट करके चला जाऊंगा. लीगल क्लास हैज टू बी पार्टिसिपेटिव, otherwise it would become very boring. So feel free to voice your opinion, no matter how wrong it is. ठीक है, now I'll explain what is void and voidable. A void agreement is something which is not enforceable from the very beginning itself. That means it does not fulfill the essential requirements of a contract, and that is why it can never be enforced under the law. Because in the eyes of law, there is never a contract that has been achieved. I'll give you a simple example. Can there ever be a contract between two? Can ever there be a contract between a person of sound mind and a person of unsound mind? No, right? So that becomes void from the very beginning. That is void ab initio. That means it can never be enforced. Now comes the second situation, which is of voidable. Voidable includes situations where the consent has been obtained either through coercion, undue influence, fraud, or misrepresentation. And the party whose consent so obtained can ask the court to declare the contract as unenforceable because their consent was not free. Now you understood the difference. So voidable are agreements or contracts which are capable of being set aside at the option of that party whose consent was not free. So suppose I put a gun onto your head and I say sign on these property papers. You sign. डॉक्यूमेंटरीली क्या दिख रहा है कि कॉन्ट्रैक्ट बन चुका है. आप जाएंगे कोर्ट में ये कहते हुए कि इस कॉन्ट्रैक्ट को वॉइड डिक्लेयर किया जाए बिकॉज माय कंसेंट वाज नॉट, and hence this contract is voidable. That means capable of being declared as void. Now is it clear the difference between void and voidable?
So,
Yeah.
if an sound mind person take the consent of unsound mind person, so can it can be stated as fraud, no?
No. Why?
Why, sir?
Because to be defrauded, the other person should come to know that he has been defrauded. Getting my point?
Yes, sir.
Can a person of unsound mind ever come to know that he has been defrauded?
No.
No. Right? Rather, the law is saying even if there is a contract by bona fide mistake हो सकती है, मान के चलिए मुझे लगा कि वो एक्चुअल में सही है, ठीक है, पर वो था नहीं, और बोनाफाइडली मैंने गुड इंटेंशन के साथ उसके साथ कॉन्ट्रैक्ट में एंटर किया, स्टिल द कोर्ट वुड से कि नो दिस कैन नॉट बी एनफोर्स्ड. व्हाई? बिकॉज द अदर पार्टी इज सफरिंग फ्रॉम इंसेनिटी. Now is it clear?
Yes, sir.
So,
Yeah.
so there is only the one difference of consent in both void and voidable.
No, there can be other situation as well. Sometimes the law may change and then also it may become voidable. Sometimes it may also become void if it is completely prohibited. Sometimes voidable उस सिचुएशन में भी हो सकता है अगर सिचुएशन बहुत ज्यादा सिचुएशन बहुत ज्यादा आउट ऑफ कंट्रोल है, जैसे कोविड का टाइम था, ठीक है, तो वहां पर लोगों की जो रिस्पॉन्सिबिलिटी थी टुवर्ड्स द कॉन्ट्रैक्ट, जो उनकी रिस्पॉन्सिबिलिटी उस कॉन्ट्रैक्ट में उसको वो नहीं एनफोर्स करवा पा रहे थे, so they also they said that the contract be declared as voidable because now it cannot be enforced in the current circumstances, but for the purpose अभी के लिए stick to consent only, that would be beneficial for you.
Okay, sir.
Now, so the first situation which vitiates free consent is coercion. Now, what is coercion? Coercion in simple terms is extortion. मैंने आपको एक एग्जांपल दिया अभी. I put a gun on Mr. X's head and asked him to sign the papers. Yes or no? What is it? It is coercion. So how the IPC defines coercion is any threat or actual commission of an act which is forbidden by the Indian Penal Code. अगर मैंने धमकी दी या एक्चुअल में उस एक्ट को किया, ठीक है, और उस एक्ट का पर्पस क्या था, सामने वाले का कंसेंट लेना, और उसने कंसेंट दिया, then the contracts so obtained through coercion would be voidable at the option of the party whose consent was obtained through coercion or through force. Right? So suppose मैंने गन दिखाई, बोला साइन करो, coercion. मैंने कोई और धमकी दी कि मैं तुम्हारे बच्चे को किडनैप कर लूंगा अगर तुमने पेपर साइन नहीं किए, तुमने पेपर साइन कर दिए, coercion. Yes or no? Right? The whole purpose of coercion is that there is a use of force in order to obtain the consent of the party which he or she would have not given otherwise. मतलब आम तौर पर उसने कंसेंट नहीं दिया होता अगर उसके सर पर गन नहीं रखी होती. Let's put it this way simply. Now what is important to understand here is the threat or the commission of the act must be forbidden by the Indian Penal Code. That means Indian Penal Code ने उस particular act को prohibit किया हुआ होना चाहिए. Suppose I say तुम इन पेपर्स पे साइन करो वरना मैं तुमसे बात नहीं करूंगा. Suppose my wife says that you have to sign these papers, otherwise I'm not going to speak to you. Now ओहो, Yeah, am I audible?
Yes, sir.
Yeah. So I was at the husband and wife example. Yeah. So suppose my wife says that that if you don't sign these papers and make the property in my favor, then I'm not going to speak to you. Now, can I? And I sign the paper. Can I go to the court challenging it on the ground of coercion? Why no? And why yes? Yeah. So not speaking is not a forbidden or is not a punishable offense under the Indian Penal Code. It's as simple as that. Right? So that would not amount to coercion. It may amount to something else, but it would not amount to coercion. Right? So threat of committing suicide, that would amount to coercion. Suppose if I say to Mr. X that if you do not sign these papers, then I'm gonna, leak your private pictures on social media. That would also amount to coercion. Defamation ka threat dena, coercion. Any act which the Indian Penal Code prohibits would amount to coercion, provided आपने उसका threat दिया हो कि अगर तुमने ये नहीं किया तो मैं ये कर दूंगा. Is it really relevant, Prarthi, at this stage? Will it be murder or not is something is to be decided within criminal law classes, not in the contract law class. कोर्जन तो हो ही गया ना, जैसे थ्रेट दिया. आपने थ्रेट दिया. Just read this line. You guys are not putting attention to the important words. Any threat. What is threat? धमकी देना. That means the act is yet to be committed. Any threat. So the moment there is a threat of an act which is forbidden by IPC, and as a result of that threat, you have entered into the contract, that very moment coercion is committed. Right? So is coercion clear? Fine. So ठीक है. So this brings us to the end of this class. ठीक है. जिन्होंने पहली बार अटेंड करी थी, I hope you guys were able to follow what I was teaching. Right. So yeah. So that's all from my side. Anything that you guys have in your mind and that you want to ask me? Fine. So we'll stop here. See you all next week. Thank you.